Afternoon, everybody. This is week 2 of our Taking Action for Your Parents campaign. Through the end of the month, we're producing special reports on the most significant issues facing adult children and their aging parents. We'll also be hosting phone banks every Friday with experts taking your calls, answering your questions directly. You'll find all the details and stories on our campaign by visiting abcactionnews.com/yourparents. The topic this week is legal planning, and we welcome to our studios Attorney Deborah Dandor of the Tampa Bay Elder Law Center to help us with some of these important documents that we should all have. Let's start with a power of attorney. What is it and why is it so important to have, Deborah?
A power of attorney is a document that you execute that delegates authority to another individual or individuals to take actions on your behalf, such as maybe managing your finances. It can be as mundane as taking care of your pets or changing your P.O. box. But it's a very important document, the durable power, because in the event that you become incapacitated, then that document allows that person to continue to act, even though you're no longer able to make decisions on your own.
I'm sure that you all in your office have heard horror stories of families that don't have it. Is it something that a lot of folks are resistant to do because they are afraid to have that conversation with their parents?
Well, people need to be careful in whom they select because you want to make sure you have the right person that you're delegating authority to. However, it's very important to have this because if you can't manage your checking account or something because something has happened, your checks can be bouncing, home can go into foreclosure, any number of things.
Now, a power of attorney is different from designating a healthcare surrogate. How does that work?
A healthcare surrogate designee is a person that you have designated to make your healthcare decisions in the event that you're unable to do so.
If a person has a living will, does that mean that they also have a healthcare surrogate, or that you really have to do each separately?
It can be in one document, or you can do 2 separate documents. However, a living will is where you are indicating to a medical provider, in the event that I am in an end-stage condition, a vegetative state, a terminal condition, here is the type of measures I would like to have taken or not taken. A lot of people say, I wouldn't want to be kept alive if, and this is your chance to tell your medical provider what you want.
There are so many websites, even at the local store, where they sell forms that say this is a good chance for you to look at a form and fill it out, and this is your last will and testament, your living will. What would you say is the best advice for folks who are considering it and how best to proceed? Please
don't do that. That would be my advice. Go to an attorney. An elder law attorney is great for seniors and the issues facing seniors especially, and can really help the family members often who are caregivers. But there can be so many mistakes with those websites because they don't always know what Florida law is, and they try to do a one-size-fits-all, and it doesn't fit everyone.
Well, thank you so much for coming in and for being part of our Taking Action for Your Parents campaign. If you would like more information on the many stories that we're doing and the phone banks and all the details of the campaign, please visit us online at abcactionnews.com/yourparents.